Hello, Dr. Bechtel here. This presentation is for the Chapter 4 content in the book, A Practical Guide to Legal Research and Analysis for Paralegal and Legal Studies Students by Margaret Phillips, published by West Academic Publishing. The full reference is on the last slide of this lecture. The Chapter 4 does cover both, covers searching and finding the legal rule, in other words, searching for legal rules, and it covers both legislation and case law. And I prefer to look at these two things separately. So what I did was I bifurcated the two. So if you watch either one of them, or both of them, excuse me, the one on legislation and the second one on case law, you'll notice some overlap, some repetition. But I wanted to make sense out of both scenarios, and thus I included them both. So let's go. In Chapter 4 as a whole, including both case law and legislation, these are the hit points, what we want to accomplish. Find and identify the applicable legal rule, identify the elements of a legal rule, identify the legally relevant facts from a fact problem when applying a rule, employ a variety of search strategies, and also ensure that the applicable legal rule is still good law. The legal rules and their elements, if it just comes down to deductive reasoning, a legal rule says, if this, then that is the outcome. An element is a component part of a legal rule, and all legal rules have elements, whether rules from statutes, from regulations, constitutions, or case law. So we're also going to cover, as noted already, some of the elements. It's a component part of a legal rule. You can break a legal rule down into these component parts, as we're going to see illustrated here, and be able to determine with legal analysis whether the rule has been met, and that legal application is applying the rules to the facts. And this is an example. A rule will have different elements. This example, the hypothetical rule, has 3 elements, and it's as simple as take each element. So first you take in this case we're talking about legislation, so you would take the statute, you would divide it up into its separate elements that must be met in order for the statute to have been fully met. So it's pardon me for the pause. I wasn't quite sure how to finish that sentence at that moment. So if all the elements are met, then the rule is met. That's what we're getting at. So if there are 3 elements that must be met, then your breakdown of the elements with the legally relevant facts for each element will establish whether the rule has been met. And if it's been met, you have a rule that's been fully met. And if there's an element missing in there, you haven't met the rule's requirements. Okay. All right. In looking at the elements of the rule, the issues, and the legally relevant facts, we need to know if all the elements are met, as I just noted, and do the facts in the problem match the elements. So as that illustration in the prior slide illustrated, here's a rule, an example of a rule. This would be a statute, most likely. The rule is, a person is guilty of burglary in the 3rd degree when he knowingly enters or remains unlawfully in a building with the intent to commit a crime therein. The facts of the case scenario, or the topic of the clients, we're assuming this person, Franklin, purposely enters a gazebo because he intends to steal a picnic table in the gazebo. All right, we take this rule, we break it up into elements. And you can see knowingly enters or remains unlawfully. element 2 in a building, and element 3 is intent to commit a crime therein. The reason these two can be placed together is you see that or is in here, so either one need to be met. If it were and, knowingly enters, and remains unlawfully, then we would have an extra element. We would end up with 4 elements. But that word or is really important, and so is and as such, do be paying attention when you're breaking down elements of a rule. Element 1, again, knowingly enters or remains unlawfully. The legally relevant facts are, according to the question, Franklin was purposeful. Element number 2, the building. The legally relevant facts are, is a gazebo a building? That's a question. Is this the issue? We're trying to come to that conclusion by the time we're finished with this kind of analysis. On one hand, a gazebo is a structure with a roof, but on the other hand, it doesn't have walls, and as such, could it be characterized as just decorative, or could it be an impermanent structure that it may not be considered a building? This is important to understand that as you're breaking these down, you may not know specifically the answer. In fact, you may not have in your factual scenario all of the facts that you need. In fact, with this kind of breakdown, you find out where the facts are that you need to explore more of. So keep that in mind. And this building situation is a good example. We have the facts, but we may need to explore additional legal rules and synthesize those later on in our analysis of the scenario. Element 3 has to do with intent, with the intent to commit a crime therein. And Franklin had, in his statement to the attorney, noted that he intended to steal a picnic table that was located in the gazebo. Now, to do this process, there are 5 steps. And the first step is you set out in writing or typing the complete rule. I recommend using an Excel spreadsheet while you're learning to do this, and actually at any time it's a very safe bet. Some people use tables to do this out of Word. I find them a bit obnoxious, but I know that not everyone uses Excel proficiently. And the second step is to parse out all of the elements of the rule. The author of the book does present this as you could take pieces and parts of the rule, parse it out, in other words, to an element, maybe using fewer minimum number of words that can be met with a fact. I don't recommend this for beginner researchers. I recommend you put the full rule and all pieces in and keep all the text about that element together in that element cell of an Excel spreadsheet or a Word table to be so that you're learning how to be cautious. But at the end of the day, more elements are better than fewer elements, which is why I profess that students in first year of this undergraduate legal research studies should go ahead and use the entire element, all the wording around that particular element. Step 3 is where you develop the chart I've been talking about with Excel or Word and separate each element so you line them up with the potentially relevant facts. And that could be column number 2. So the first column could be elements, the second column could be facts. And each element then would have an associated facts. And then with that, in that next column to the right, I realize in the illustration provided by the author, they have used the element on top with the facts underneath it, like in that previous slide. But you might find it better to do something like this. Pretend this is a blank chart, and here in the first column, you could type in the elements one by one, and pretend this is the second column, and it could be labeled facts. And for that element, you would, just like we did in that previous slide. So you're not doing anything different. I just kind of prefer the other format where it works from top to bottom instead of left to right. It may help you too, because there are other steps that we take in this class. Step 4 is you list the applicable facts with each element. Sorry for that repetition. and you look for confirmation. You ask yourself by looking at the rule and the facts, the element, the element of the rule plus the facts, do the facts confirm that that the element has been met or not met? Because again, you meet all elements for the statute to apply, or if you meet some of the elements, it's not going to apply. It may apply, but in a way of saying, no, there's not a finding of guilt in this situation or a finding of fault in a civil situation. But be open to revising your elements as you research. This happens. When you start with the elements, you're lining them all up cell by cell in that first column. And as you start adding facts into the game, you might say, maybe you need to repeat the same facts with a different element, or maybe you need to be open to revising, maybe splitting an element that you included too much text in. As we talked about in step 2, more can be better. So be open to revising things. Next, we'll talk about the things to remember when you're researching. In law, we may be integrating legally relevant facts into our searches. So we're looking for legally relevant facts, as in that illustration of the table with the elements plus the facts underneath the element. So you may need to integrate those facts into your searches in your database that you plan to search. So that's another reason why that's helpful to have those facts lined up in that chart. Always check the date of your legal rule, and always make sure your legal rule is still good law, which means it's still current, or at the time of the offense, it was current at that time, because legislation has a future effect. It won't have a past effect, but it depends on the context of the time that the act took place. It has to be either a legal activity at that time, and as such, that date the dating is very important, and you need to make sure the law hasn't been repealed if it's a current situation. So a more in-depth look at your research strategies for statutes or cases. It doesn't matter what you're researching. These are excellent tools here to help you through that in-depth look at the strategies. Research is a recursive process. You're working with statutes first when you take my courses. However, you may find that you need to return to your research. You may find a statute within a statute that you need to look at, so it's recursive in that way as far as legislation is concerned. And there are multiple steps or layers to work through. We'll go through some of that. And then as additional information that you receive in your research process may inform you more and also possibly help you to revise your searches. And that's one of these areas of recursive process, like a hamster wheel, or think of it as rabbit hole. You go down the rabbit hole, and you may or may not find what in the next iteration of the next thought or idea that comes with this recursive process. You may end up in a rabbit hole and stop because you may not find what you're looking for. All right, so the foundations of this area of certain research strategies include Chapter 2 of the textbook and Chapter 3 of the textbook. In this case, because Chapter 3 delves into more of the court system, which is something more applicable to case law research. Not that there wouldn't be any court system thought going into this type of legislative research, but it's not as pronounced as you see it as it is with case law research. So Chapter 2, just this is one slide on Chapter 2. I recommend you go back and review Chapter 2 lectures if you wish. You're going to sort out the legal mess by saying, where am I, whose law governs, and which courthouse will I go to? And in statutory research, we're talking about where am I? Am I federal or am I state? If I'm state, which state is it? And the courthouse can help you with this process too, but the courthouse is a little more pointing to jurisdiction and mandatory versus persuasive precedent, which is found in case law. And we'll get to that in the second part of this that I dissected into the case law piece. But where am I and whose law governs? Really paramount considerations when we're researching legislation. All right, a more in-depth look also at the strategies. You need to strategize when you're using databases such as Westlaw and Lexis, FindLaw, other electronic resources. And there's always a role of the legally relevant facts in your searches where you design your searches with facts. It's not that you're asking, is this against the law? This has to be described to some extent, and those legally relevant facts are what you need. You also need to integrate areas that are available in Lexis and Westlaw. We'll go over that to determine whether the law is still good, and I should say the integration is how are you going to approach your research within one of those two databases or a different database. There can be multiple interrelated legal sources, and then also when we get to case law in that section of the lecture, you'll be learning more about how to rank their authority. And by the way, that reflects back on chapter 3 of the textbook. The importance also, the dates of it are very important. You're always needing to watch the dates of the source of law to determine the rule's validity and correctness. And in legislation, that is whether as I pointed out earlier, is the law still in effect? Has it been repealed? Does it exist at all? And are you applying the right law? And that comes with experience and time and carefully being curious about what you're reading about when you find rules of law. Dates of sources are extremely important, and we'll use this concept as an understanding of later in the lecture of shepherdizing and key cite. You're always going to be looking at the date of your legal source. And this applies to both legislation and case law. It helps determine the validity or correctness of the source. And you can test it against other sources, maintaining and updating the functions of the database, which are shepherdizing in Lexis or key cite in Westlaw. And there's some other little tricks and tips to do that too. So dates are important because they highlight any issues regarding the primacy or priority of sources. And when we have multiple sources, we have to look at the source with the most recent date. And an example, case law on an issue, but an issue being a legal problem, but the legislature subsequently passed a statute on that same issue that's completely conflicting with what case law has brought about. And my favorite example would be the charitable immunity in hospitals, which was a common law principle for many, many years in the United States. And judges began to notice, this isn't right. A person shouldn't go to the hospital because it's a charitable hospital and that hospital have immunity when a public hospital does not. It's not necessarily looking at the fairness between types of enterprise. It's about the fairness and justice that people are deserving of, whether they go to a private hospital or a charitable hospital. So the legislature can come in and codify or codify, whichever way you like to pronounce that, meaning take a common law principle and turn that into legislation that totally abolishes it or keeps it, whatever the case may be, or revises it or tweaks it. Just remember, the legislature can always disagree with the courts. They can always promulgate statutes that'll circumvent prior case law decisions. So these legislation, I always like to say that the legislature always has the last word. Now, this slide, in contrast with the case law one, is a little different, but it's very similar. Keyword searches are important, and you need to try many different searches if you don't come up with your answer right away. Many times you do. And then you're also going to pay attention to filters and the databases you select. So as we navigate learning legal research, you're going to find that the closer you can get to the container of information that would have it, I'll give an example. When you ask these questions, is this problem federal or state or both? And if it's state, for example, you know that you're going to filter down to the state you're in. In my case, I'm in Florida. So if I select the database of Florida statutes, I'm going to have a lot fewer results than if I select the whole United States. It's obvious. And being careful that's a form of filtering. It's like your pre-search filtering is finding that perfect bucket to start with. That's going to bring you the closest as possible to the result you're looking for. Advanced searching is available, of course. Mr. Boolean and an advanced searching technique that uses symbols that enhance to either broaden or narrow our search. Sometimes quotation marks are very helpful. The little /s means in the same sentence, /p in the same paragraph. Exclamation means search all endings of a word, and you can also do field or segment searching or exclude certain words or phrases. I will say that my experience with my years of research have shown that the more legal knowledge I build the more legal reading I do, the more legal knowledge I get from that reading, I begin to understand when situations arise and I'm searching for something and wording that could be confused because it isn't clearly words that would come together or close together in a judicial opinion, for example, would tell me, would be something that I have from learning about the law and reading about the law frequently enough. But at the same time, these kinds of search techniques do help you even if you're not familiarized yet with that. These types of search strategies can also come in handy when you get too much information and you start to look at that information that comes to you and you can conclude from it that maybe you should find this word and this word in the same sentence, or this word and this word in the same paragraph. And then the exclamation is really helpful because some terms can be, your words can be, the English language is that way, where we want to change the ending instead of some summary, maybe summarily. And in that case, I would put summer in an exclamation so that I could pick up on either word. And that may be too much. So again, these things can expand your research, broaden it out, bring you more results or fewer results. And I think that's one of the classic those examples are classic for when Boolean is really beneficial to the researcher. Okay, so constructing your searches. We need to remember, use keyword searches. If you're searching for case law and you find a good case, that one good case can draw you, because of the research system, that recursive system of research, one good case can help you find other good cases. There's a lot of different ways that can help you in that respect, such as Westlaw KeyCite, and there are KeyCite is a good one, and there are cases cited within cases. The judges rely on precedent, and you might find valuable research in that one good case. So in addition to that one good case, you have other cases that have been relied upon by the courts in similar situations. And remember to filter for jurisdiction, and this goes back to my earlier point about the filtering with the databases. Like I said, if you're in federal court, hone in on the jurisdiction that you're in, because that's where you want to find your rules of law in the first place. You want to be in your own jurisdiction because then it has more authority, more power, more precedent, especially for case law. But when you're searching statutes or legislation, if you will, you're also, as I pointed out earlier, if you're in state A, like I said, I'm in Florida, My strategy would be to open the statutes of Florida, begin there. That's my first pre-searching filtered aspect of it, and then I do my search, and I can also filter that search further. For example, Westlaw will come up with, if even in statutes, will come up with a lot of, say I come up with 685 hits, but I have a filtering location on the left-hand margin where I can drill it down to just tell me statutes, not case law, not secondary sources, not regulations. But at the same time, there can be important information there. But for your, initially in filtering it to find a statute can be very beneficial. Maybe return later for a larger look, a more broad approach. And don't forget to use Boolean and advanced searches. Westlaw does have advanced search capacity in their platform. All right, now print research methods are awesome. I still love print research methods, but a print research is not necessarily out of a book. An online search is still considered a form of print, but it's electronic print. Point is that online or with the books, which should definitely be done? Well, the location is your list to look at when you do your research is really helpful. I like to use the analogy of a textbook for this slide, because if you look at a textbook, at the beginning of the book, there's always a table of contents. So a location in the beginning of a textbook has information. It has a list of chapters and the titles of the chapters, and there's information in those titles. Some table of contents are expanded and even have some topics that are covered in each chapter. Very helpful for beginning research. Sources themselves, however, are found in statutes. So imagine opening the book to the table of contents, seeing that chapter 3 is about civil procedure, and then you go to chapter 3. Imagine those are the rules of law, and they will cite to rules of law in your textbook. But in this case, I'm just using this analogy to help you visualize this, since you're new at this. The type of list that's also available are lists of legal topics. Your textbook might have a table of cases and an index in the back of the book. Those are also lists that are beneficial in your legal research, especially if you're researching your textbook. But at the same time, these can be helpful tools. And it's a secondary source, a textbook is. You might find some answers to begin with and start drilling down from there. Point is, these lists should be consulted, just like statutes have titles. And with those titles, you can get context. Sort of the civil procedure is a title in the Florida statutes. And so if I'm dealing with something that has to do with civil procedure, I might find what I'm looking for there. If I'm dealing with fruit trees, I might look through the table of contents, which are the titles of the statutes of Florida, and look for agriculture, and so on and so forth. There's a big picture from those title chapters. Whereas in the index, it might say something like fruit trees, see citrus. And that could take you to down another avenue, and can also help you with your key terms, your keyword searching. This diagram is also from the textbook, diagram 12, and when to look, list to look at. Right after the beginning and at the end, you find lists. We have sources found in statutes, administrative regulations are useful here, and your type of list would be maybe the table of contents, returning back to my analogy earlier, not my analogy, but my description earlier that statutes have title names, and that can be a useful benefit. At the end of the book, there can be digests for case digests. We'll get into that in a later segment. Statutes and administrative regulations. And there could be an index, and that index is also a type of list. These are helping tools. Allow them to help you. at the beginning of the list, kind of repetitive, but I think the author put something like this together. I thought it was useful. So list 1 is the beginning, list 2 is after the beginning, and list 3 is at the end, like your textbook. And also extremely important with this process is checking for the updating the legal rule. Now, Westlaw uses KeyCite. That's what we use at our school for checking the updating a legal rule. Lexis is used at other schools. The KeyCite will give us red flags and yellow flags. So we want to look for red flags and yellow flags when we're doing our research in Westlaw. Even a statute might have a yellow flag, might even have a red flag. You think you found what you want, but a red flag shows you that, oh, let me check. Oh, the history tells me this law's been repealed. Okay. As such, I'm not going to use that law unless the incident happened before the law was repealed. Getting to also, returning to an earlier chapter in the textbook, I think chapter 1, we always want to rely on primary sources. They're always more, if we're ranking, they're always more important than secondary sources. Another way of sorting it out and ranking it is looking at the dates of the legal rule. Whether if you're researching case law, you have mandatory or otherwise persuasive precedent, and that's covered in chapter 3, and I'll go into that in just a minute. And the relevancy in light of the legally relevant facts. These are just things you see. You're reading, you're finding a rule, but you're going, it seems a little askew. I think one of my examples might be years ago, I had my students in this class researching a landlord-tenant problem, and I remember the students came in on the next class. They were asked to do Westlaw research on a topic about the rental agreement. We had a case scenario about a rental agreement, and everybody's just been in a lot of arguments about the condition of the home, etc. But when I did this work, when the student came in, she told me, she reported out loud her answer that she had found in Westlaw, and I'm like, wow, where'd you find that? I've been all over these statutes. I haven't seen this. Well, she found the statute that said the perfect thing, but it wasn't relevant because it was a completely different area of the law, Uniform Commercial Code, which had nothing to do with this residential family home. In other words, context matters, and it will help you greatly to read those title names of statutes when you're researching statutes. Look to see that you are in the right context. If you are in something about landlord-tenant in a single-family home, you need to make sure that where you're consulting really will apply. How do you rank? My apologies, I had some of the wrong slides attached here. That's what happens when you bifurcate something. It can be really confusing, especially with PowerPoint. I don't know why I have that problem, but I do. I finished up the key citing. Now let's go to, the good research habits mean you have a plan. You've made a plan in advance. You keep track of what you do by taking your notes. Use folders in your database. Maybe you will use an Excel spreadsheet. I will be teaching some habits for this as we navigate the class. And you can also create alerts for your fundamental sources so you know if something changes. So if you have a statute, for example, or a case, you can set up an alert in Westlaw that allows ask Westlaw to send you a push alert or an email if something changes in that law that you need to know. And then when do I stop searching? When you find the same sources over and over and over, no matter how far you search, no matter what the rabbit holes you go down, you finally say, I cannot find anything else. And sometimes this type of research can really be the longest project. But always check with your supervising attorney. How much time do you anticipate I'll be spending on this, or what would be the max you want me to spend? Lawyers will have a good estimate of how much time it'll take you to complete a research project. Get that information immediately when you first take in the assignment. so that you're not going outside and spending too much of the client's money or causing a problem of the lawyer needing to write off your time. And keep track of your time. Keep this information for you and your supervisor, whether you're billing the time, whether your lawyer's billing the time or not. It's an important indicator about how far you've dug, and keeping track of good notes, keeping good notes of your research. And Westlaw also provides you with tracking tools, history tools, and you can rely on that quite well too. You can even send your supervising attorney your research history by email so that they can look at what you looked at. And that can be can help an attorney that maybe one that hasn't spent a lot of time working with you know what you've done, where you've gone, how many rabbit holes you went down. So keeping track of time, keeping notes, and making sure you understand the objectives of the assignment. And this is the book that this PowerPoint presentation is designed around. Margaret Phillips' book, Legal Research Analysis and Analysis for Paralegal and Legal Studies Students, and that's by West Academic Publishing. So that concludes this lecture on legislation research as it relates to Chapter 4 of this book. Thank you.